Good evening. We have the regular workshop meeting of the mayor and the city council of the city of Prospect Heights.
We may not have a quorum yet.
We may not have a
No,
quorum yet?
I think Alderman Williamson is on his way.
No, I beg to differ with you, Kevin. I'm,
2, 3, oh, you are, you're on.
yeah,
All right, we're good, thank you.
we can go. In the council chambers of Prospect Heights City Hall, 8 North Elmhurst Road, Prospect Heights, Illinois. Mayor Nicholas J. Helmer presiding, that's me. During the meeting, it is anticipated that there will be discussion and consideration of, and if so determined, action upon the matters contained in the following. If you don't have a schedule, it's available over there. We're also, as a reminder, broadcasted on WOW Channel 17 and AT&T UVerse on Channel 99. So gentlemen, ladies, be on your best behavior because they're going to put you on the air, all of us. He's the man that does it. Mr. Tibbetts, how are you this evening? Good to see you. All right, let's go with the roll call for a quorum, please.
Okay, Alderman Messer,
Here.
Alderman Ludwigson.
Keep going.
He's on his way, okay. I know Alderman Williamson's going to be on, is on his way, also he's running late.
Alderman Dolick
Alderman Dolick,
Here?
and Mayor Nick Helmer.
and yes, Mayor Nick Helmer is here.
So we do have a quorum, and we can
And Larry
proceed.
Rosenthal is on speaker.
And Mr. Rosenthal is here too.
Mayor, may I make a
Yes, go ahead.
Pursuant to the city code, we need a motion to permit Mr. Rosenthal to attend electronically. Can I get a motion?
I move to permit Alderman Rosenthal to attend tonight's meeting through electronic means.
Second.
All in favor?
Aye.
Good. Larry, you're official as soon as I turn my phone off. Well,
Thank you all.
Thank you. All right, let's move on. Thank you. The roll call for a quorum is complete. We are legally authorized to proceed. Pledge of allegiance, please. Treasurer Tibbetts. And to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, we can move forward. Joe, please.
Well, thank you, Mr. Mayor. First item of business is approval of the minutes. And we have the November 27th regular council meeting minutes and the November 13th executive session minutes. Do we have any additions or corrections in either one?
We just may want to add for the executive session that it's not for public release.
Okay, not for public release. And if not, I think we could do an omnibus motion for both minutes if there are no additions or corrections.
Motion to approve as presented.
Second.
All those in favor say aye.
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 Thank you. We don't have any presentations tonight, nor appointments, confirmations, proclamations. Any citizens' concerns?
We do not have any.
Okay. Which brings us to staff, elected officials, and commission reports. First item is item 8A is the City of Prospect Heights Water Quality and Compliance with National Pollution Discharge Elimination Standards Report from Caitlin Burke from DeWalt Hamilton, the city's consulting engineer. Thanks for coming out tonight.
Thank you for having me. So I want to go through a few things. My name's Caitlin, and I'm an environmental consultant with DeWalt Hamilton, civil engineering firm. So I handle the MS4 program for Prospect Heights, which is the municipal separate storm sewer system. And the city has a permit through IEPA. It's called NPDES, National Pollutant Discharge Elimination System. So it essentially allows you to discharge stormwater into the waterways. So the permit requires a few things. One of them is that we do water quality testing, which I will present on those results briefly. It requires annual outfall inspections, which I believe the city does on its own. And then it also requires that the city has a stormwater management program plan, which I have this here, and I can leave it with you to so you have a hard copy. Basically, if the EPA ever came to audit you, you want to pull this out, and it has all the information about how you stay in compliance with the permit. To go through the test results briefly, in the past, we've sampled during dry weather, and this year, the permit was changed a little bit to sample after a quarter-inch rainfall. So all the parameters are going to be higher than they normally are, just because stormwater is inherently more polluted. So that's why it'll show higher levels for fecal coliform and total phosphorus. And we sample at 3 sites, and I believe it's in your packets if you want to look, but it's at Cornell Avenue, Wheeling Road, and Camp McDonald Road. So we have 2 what we would consider upstream locations and 1 downstream. And there weren't any, pollutants of concern. I know the fecal coliform levels came up high, but it's what we would expect for stormwater. So if anyone has any specific questions about that or anything else about the permit in general, feel free to ask.
Well, let me start by noting that Alderman Williamson and Alderman Ludwigson joined the meeting approximately 20 minutes to 7. And if there are any questions, please ask. Alderman Williamson, anything? I have no questions. Alderman Messer?
I have no questions.
And we have Alderman Doldick
No questions, thank you.
and Alderman Ludwigson.
Just a quick one. Do we ever take those readings outside of a rain event just to see where we are as a baseline?
We actually have it from last year. We took them during dry weather.
Okay.
And the report shows a comparison between years. So I guess those could count as your baseline.
Okay.
But what we really care about is stormwater, right? So I think it's more important now that we're sampling after a rain event. Even though the difference between the two, it might look like a spike, but that's the reason why. Any other questions?
Alderman Rosenthal.
Alderman Rosenthal, do you have any questions?
Alderman Rosenthal, are you here?
Yes.
Do you have any questions?
No.
Thank you.
All right.
Thank you very much.
Thank you.
Thank you.
Before we go too much farther, let's have everyone identify that's with us this evening, starting with Alderman Williamson and coming down the line. You're here.
I'm here.
Thank you. Mike?
Excuse me, Mayor, was this on item 8A? You asked if I had questions?
Yes.
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 I do have one question on that, I'm sorry.
All right, go ahead.
I read the section on recommendations along with the rest of the report, which is on pages 10 through 11. And my question is, who will, within the structure of the city, be given this report to move forward with the recommendations as presented by the consultant? If there's no objection to the report, that means I assume that means we would accept it, and then who would move forward with their recommendations at that point?
How about our attorney?
I think Alderman Rosenthal, I think that would be either up to Joe and the mayor. But you're right that if the council accepts the report, it's a more of an administrative decision unless there's a statutory, somebody who's designated by statute who has to be responsible for implementing these.
Yeah,
So
the
if I
only,
understand you correctly, it's an administrative decision?
Yeah, and the consultant is actually going to respond as well.
Elucidate.
I just wanted to say, yeah, the only requirement is that we do the annual water quality testing. So whatever the results are, it's up to the city if you want to pursue any
I
additional.
can't hear what she's saying.
She's saying that the only statutory requirement is that the testing is done. There's no statutory requirement that a designated officer, official be appointed to implement the recommendations. So that's an administrative, it's up to the administrator and the mayor to implement it.
And Alderman Rosenthal, if I could make a general comment, the National Pollution Discharge Elimination Standards is something that as a municipality we're conscious of as far as to make sure that our city actions and city efforts that keep us within the good graces of those areas That's the responsibility of, part of it is myself, part of it's the city engineer, Pat Glenn from Gaywalt Hamilton, and part of it is Public Works and Mark Roscoe, so.
Okay, I understand that, and that's fine. I would like to get, if it can be next month or whenever it's, or another time that you designate, when we can get an action plan of what you propose to do with the consultant in terms of making our water quality better.
Okay.
Any
Yep.
comments?
Well, I can email you next
Okay,
month.
very
We'll
good.
figure it
Thank
out,
you.
so.
Thank you
All
very
right,
much.
thank you.
Thank you.
Thank you, Alderman Rosenthal.
So will that be at the next meeting or next month or what?
Give us a month.
Okay, that'd be great.
All right, thank you. Identities, Michael?
Michael Ducharme, Director of Finance.
Mark Roscoe, Superintendent of Public Works.
Peter Falcone, Assistant to the City Administrator.
Dan Peterson, Director of Building and Development.
Wendy Morgan Adams, City Clerk.
Joe Wade, City Administrator.
Kevin Carney, City Attorney.
Karen Schulteis, Deputy Clerk.
Al Steffen, Chief of Police.
Thank you, Mr. Treasurer. Moving on, Joe?
Well, it's the annual police awards. It's been a very good year from the police department, a number of great achievements. And at that, I'll turn it over to Chief Steffen and Deputy Chief Zalaki.
Thank you, Joe.
In the words of Ed Sullivan, we got a big, big show tonight. We have lots of folks up for awards, and I just want to thank Mayor Helmer and the council, because I'm truly blessed to be standing before you in my favorite function as the police chief, which is recognizing our folks for doing good deeds and their service. The first awards, actually, we were going to have a gentleman that is one of our community crossing guards join us tonight to honor his service to the city, but because of an advanced illness, he could not make it. But I would like to recognize Leroy Finn for 3 years of service to the city of Prospect Heights as a crossing guard, and we'll be making arrangements to, we have a little award that we're going to give him, but we'll make arrangements to get it to his family. Our first awards recognize our officers and staff who've assisted in making Prospect Heights a great community and a great place to live. Our employees and our citizen volunteers, whom I will recognize at a later date, help make the city of Prospect Heights something truly special. A lot of these officers here have what I call a servant's heart. It's not just about enforcing the law, they give back to the community. And as such, I'd like to recognize our officers who participated in the following community service events this past year. A lot of these officers, they've volunteered for everything. So what I'll do is I'll announce the event and who participated in each event, and at the end, we'll just hand out the awards because there's so many to give out for each of these events. Starting off with the Torch Run Cop on a Rooftop Dunkin' Donuts event, which helped raise money for the Torch Run and for Special Olympics. Corporal Bill Caponegro, Officer Jocelyn Garza, Records Clerk Pablo Martinez, Officer Mark Buffont, Officer Dean Savis, and Officer Corey Simpson all spent many hours on a cold morning raising money for the Torch Run on the Dunkin' Donuts on Milwaukee Avenue. They helped raise money for the officers who actually ran in the Torch Run, which would be Officer Milo Derman, Officer Kevin Lang, Records Clerk Pablo Martinez, Officer Keith O'Connor, Officer Christopher Skeet, Officer Mike Smith, Officer Alan Tebow, and K-9 Bain. I believe his whole family was there too, weren't they, Alan? Yes, sir. They all ran with us. And Officer Matt Willis. Over the summer, we also conducted our outreach activities, and pretty much the whole department helped in providing some great summer fun for some of the kids on our east side of town. And this couldn't have happened without the volunteer work of Corporal Bill Caponegro, Officer Mike Hoglanese, Officer Pardeep Deal, Corporal Jesus Duran, Officer Jocelyn Garza, Officer Kevin Lang, Officer Keith O'Connor, Officer Mark Pafont, Officer Dean Savis, Officer Corey Simpson, Officer Mike Smith, Corporal Bill Seworth, and Officer Mitch Weber. More recently, we've had, for the past several years, participated in a number of events for the American Cancer Association. One to raise awareness for breast cancer and donations, and another for men's health. And tonight we have as a representative from the American Cancer Society, Julie Lawrence. And if I can get Ms. Lawrence up here to join me. I believe we have a couple of checks for you tonight. We have a check for $3,860 for the breast cancer awareness. And for the men's health awareness, we have a check also for approximately $1,900. And you know, speaking on behalf of the officers here, it's something that they look forward to doing every year and participating in. And it's a big thing for them, and we think it's a great cause, so thank you so much.
Thank you. Thank you for your continued involvement.
Okay. The officers who stood out many long, cold hours at the intersection shaking down motorists for donations. Officer Mike Hoglanese, Officer Pardeep Deal, Officer Jocelyn Garza, Officer Kevin Lang, Officer Keith O'Connor, Officer Mark Pavant, Officer Corey Simpson, Officer Alan Tebow, Officer Bill Ware, and Officer Mitch Weber. We also had, for the No Shave November campaign, Officer Mike Hoglanese, Officer Pardeep Deal, Officer Milo Derman, Officer Kevin Lang, Records Clerk Pablo Martinez, Records Clerk Evaristo Mendez, Officer Keith O'Connor, Officer Mark Pafont, Officer Corey Simpson, Officer Christopher Skeet, Officer Mike Smith, Officer Alan Tebow and Bain, and Officer Bill Ware. And from that, the most recent event that we participated in was the Prospect Heights Thanksgiving Food Drive. And again, all hands on deck. Record Supervisor Margie Bolger, Corporal Bill Caponegro, Officer Mike Hoglanese, Officer Pardeep Deal, Officer Milo Derman, Officer Kevin Lang, Officer Keith O'Connor, Officer Mark Pafont, Officer Corey Simpson, Officer Mike Smith, Corporal Bill Seworth, Officer Bill Ware, Officer Mitch Weber, and Officer Matt Willis helped collect donations that ultimately helped provide Thanksgiving meals for over 65 families. And if the officers that were involved in these events could step up here and join me, I would appreciate it. Patrick, can you get all this? Give us a moment, please. No. This award is worn as, in the form of a ribbon on their uniform. It's a red, white, and blue ribbon that you see these officers wearing, and for each event or subsequent event, you will see a star for every subsequent award. Patrick? Oh, can you catch that? Get on. May I be joined at the dais by Sergeant Mike Stone, Officer Jocelyn Garza, Officer Kevin Lang, and Officer Matt Willis.
It's gonna be his whole.
This is the Unit Citation Award. Whereas while it is understood that excellent police work is done routinely by good officers and civilian employees, let it be known that the above-named officers were part of a unit that displayed teamwork by working together for the successful resolution of a critical and serious problem. Whereas on September 26, 2017, Sergeant Stone responded to a report of a despondent, suicidal, and intoxicated subject who left his residence on foot while carrying a black backpack containing a gun, bullets, and the subject's cell phone. Sergeant Stone helped coordinate the response of his fellow team members, and he had dispatchers that were authorized to ping the phone of the subject to enable to attempt to ascertain a location. Sergeant Stone led his team, who then coordinated a perimeter of the area and authorized calls to area schools to place the respective schools on lockdown. Sergeant Stone, Officers Garza, Willis, Lang, and Deputy Chief Zalaki, along with assistance from the Mount Prospect Police Department, began a search of the area. While on foot, officers were advised of a subject matching the description of in the area of the Robbery Golf Course. As officers searched, they were advised by numerous golfers of their observations and that they'd seen the suspect and had given reports of his location. Officers Willis and Officer Lang subsequently located the individual in the bush line by the 8th hole of the golf course. Utilizing creativity and professionalism, Officers Willis and Lang de-escalated the situation and were able to convince the subject to peacefully agree to let the officers take his backpack and agree to be transported by Prospect Heights paramedics. Officers recovered a 9mm handgun and 2 boxes of ammunition from the subject, and later they also recovered other shotguns and rifles from the subject's house. Due to these officers' training, quick thinking, and professionalism, a dangerous situation was avoided and a troubled individual was able to receive the attention he required. Therefore, through the work of Officer Sergeant Stone along with Officers Garza, Willis, and Lang, which led to a nonviolent resolution and helped the person clearly experiencing emotional trauma seek treatment, they also helped uphold the best traditions of law enforcement service, and it reflects great credit upon themselves, their unit, and the Prospect Heights Police Department as a whole. Therefore, based on the awards and commendation program of the Prospect Heights Police Department, and because of the officers' diligence in this process, I am pleased to present these officers with the Prospect Heights Police Department's Unit Citation Award.
Accommodation for Captain.
Can I have Detective Sergeant Perlier and Detective Bill Capinator join me at the dais?
Oh, good.
This is the Departmental Accommodation Award, and it is awarded to Detective Sergeant Perlier and Detective Bill Caponegro. Whereas it is understood that excellent police work is done routinely by good officers and civilian employees, let it be known that the above-named officers displayed initiative and alertness decidedly in excess of the norm in this particular instance by investigative perseverance and doggedness following a report of a sexual assault. Whereas in March of 2017, the Prospect Heights Police Department received an allegation of sexual abuse from a juvenile who'd sought medical treatment after claiming he'd been abused by 2 men at a home in Prospect Heights. Prospect Heights investigators identified the suspects as the parents of a young man whom he'd recently befriended at a church in Chicago. This friend had invited the victim to a Prospect Heights residence to spend the night, at which time the abuse allegedly occurred. As investigators began to build a case, they uncovered other victims of abuse and ultimately discerned a pattern, whereas the parents used both an adoptive and a foster child to lure juveniles to their home, where the offenders groomed the children for their sexual gratification. Despite mishaps on the part of the Illinois Department of Children and Family Services and the Children's Advocacy Center, who initially tipped the suspects off, leading them to flee the state, Prospect Heights investigators William Caponegro and Detective Sergeant Mark Perlier did a masterful job at downplaying the seriousness of the investigation, which helped convince the suspects to return and ultimately led to their arrest on March 30th, 2017. Search warrants served subsequent to the arrest led to the seizure of numerous electronic and digital devices which had been cleared by the suspects when tipped off, but under forensic examination revealed a large amount of evidence which was not only used to support the victims' stories but also helped identify additional victims. On October 24, 2017, Anthony and Christopher Wheeler appeared before a judge in the 3rd District Courthouse in Rolling Meadows. Christopher Wheeler was served with indictments for 12 counts of aggravated criminal sexual assault with force, 10 counts of criminal sexual abuse, 26 counts of child pornography, and 2 counts of aggravated domestic battery. Anthony Wheeler was served with indictments for 8 counts of criminal sexual assault with force, 5 counts of aggravated criminal sexual abuse, and 31 counts of child pornography. It was the result of these detectives' training, experience, and investigative prowess was led to the arrest of the Wheelers and the uncovering of a trove of evidence which was used to support the claims of the victims. Therefore, based on the awards and accommodations program of the Prospect Heights Police Department, I am pleased to present on behalf of the men and women of the Prospect Heights Police this departmental commendation for your investigative efforts and diligence in pursuing this investigation to its conclusion, resulting in the charges aforementioned. Thank you. Officer Alan Tebow and Officer Mitch Weber, please join me. This is a life-saving award. This life-saving award is awarded to Officer Alan Tebow and Officer Mitchell Weber. Whereas it is understood that excellent police work is done routinely by good officers and civilian employees, let it be known that the above-named officers displayed initiative and alertness decided in excess of the norm in a particular instance by responding to the aid of another person facing imminent death and assisting in life-saving by. On November 3rd, 2017, Officers Weber and Tebow responded to 1411 Olive Street for a female who had collapsed and was non-responsive. Upon arrival, the officers found the subject on the floor of her living room and observed her skin turning blue in color. They also could see that she wasn't breathing properly. Acting on training and experience, Officer Tebow began CPR compressions as officer prepared an AED. Prospect Heights paramedics then arrived on the scene with their own electronic defibrillation equipment, and as the paramedics set up their equipment, Officers Weber and Tebow alternated compression cycles, keeping the victim alive. The subject was eventually transported to Northwest Community Hospital where she received life-saving care. The Prospect Heights Fire Department commended these officers' quick response and credited their use of CPR in helping save her life. Therefore, based on the awards and commendations program of the Prospect Heights Police Department, I am pleased to present these officers with Prospect Heights Police Department's Life Saving Award. I have another life-saving award. This is for Sergeant Todd Gadare and Officer Kevin Lang. Sergeant Gadare cannot join us because of the weather conditions. Kevin? On June 14th, 2017, Sergeant Todd Kadare and Officer Kevin Lang responded to a call of a female subject who had taken a lethal mixture of prescription narcotics and alcohol. Dispatchers advised the female was barely breathing and had a faint pulse. Upon arrival, Sergeant Kadare and Officer Lang located the female in a bedroom. The responders observed her lips to be blue in color and that she had difficulty breathing and was barely breathing at all. Based on training and experience, Sergeant Kadare administered a dose of Narcan, and there were no signs of improvement. A second dose was prepared by Officer Lang, who then gave it to Sergeant Godare, who helped administer the second dose intramuscularly. The first one was through the nose, and the second one they ended up doing an injection. Once the second dose of Narcan was administered, there was immediate signs of improvement. Her lips returned to the normal color, and she began breathing regularly. Prospect Heights Fire Department arrived on scene shortly thereafter and transported the patient to the hospital for further medical treatment. If it had not been for the training, experience, and fast actions by Sergeant Gadare and Kevin Lang, this woman would have passed away prior to the paramedics' arrival. Therefore, based on the awards and commendation program of the Prospect Heights Police Department, I am pleased to present Officer Kevin Lang and Sergeant Todd Gadare with the department's life-saving award. Where's Pete? Pete was part of the, I'll correct that in just a second. What are you expecting? It is my distinct pleasure to present the Prospect Heights Police Department's Officer of the Year to Kevin Lang. Where it is understood that excellent police work is done routinely by good officers and civilian employees, let it be known that Officer Kevin Lang, a 5-year department veteran, known for his easygoing demeanor and affability, as well as overall good character, is awarded the Police Department Employee of the Year. This 2017 Prospect Heights Employee of the Year has served as a police officer with the department since 2012, prior to which he served as a civilian volunteer and records clerk. He's received extensive training as an evidence technician and was selected to the Northwestern Suburban Major Case Assistance Team's forensic unit. He's overseen the Prospect Heights Evidence Collection Program. He serves as a field training officer for new recruits. He acts as an officer in charge in the absence of a sergeant. And he participates in almost every extracurricular activity that we have on behalf of the Prospect Heights Police Department, to include the Summer Outreach Program, Thanksgiving Food Drive, the Law Enforcement Torch Hunt for Special Olympics, and fundraising activities on behalf of the American Cancer Society. He has the respect of his coworkers and supervisors, as well as the rest of the staff at City Hall. Please join me in congratulating Officer Kevin Lang as our officer.
Okay. Good call.
I was remiss because I missed one award tonight, and along with the Officer Pardeep deal, was part of the unit citation award. Do we have it here for Pete? Oh. Pete's mother, I am so sorry. We'll make it up to you. That will conclude the awards ceremony on behalf of the police department. Thank you.
You know, I feel like we're part of Blue Bloods tonight. We've got great officers, great people. We also have two of the commissioners here, and they're not named Reagan as they are on Blue Bloods, but they are named Jerry Meyer and Joe Fiorito. They're the police, they're the commissioners of the police department. So welcome, gentlemen, and I think it's fair to announce every time I see Jerry is to say that he was the instrumental guy that got the police department started in the city of Prospect Heights. And I've been living here for a long time, and I gotta tell you, we had county police, nice guys, nice people, but they never showed up. So I'm pleased to have you here tonight and the things you do. I know Susan is not here, but thank you, thank you, thank you. All right, get out on the street, please. There's nobody out there.
I'm going home.
Good. Carefully, carefully. Go carefully. Let me say this next thing, and then you take it back over.
Okay,
after
sure.
this. Hi, Laura. I'll big messer wanted this.
Oh, the ones in Hall.
Yeah. What were you gonna say?
She actually had requested the garage, and I just put on the record the clarification of the email that I sent out, so I'm gonna ask for recognition.
Good, good.
After Joe reads the agenda.
Yeah, all right, thank you. Moving on to item 8C, 8 Charlie. Alderman Messer requested that we review the Plaza Drive status. Alderman Messer?
Oh, I requested the status. I don't have a status. I believe Mr. Peterson was going to provide the
You got
status
the
for us.
status?
I don't have that status. I'm looking for the status.
You're right, of course. Director Peterson?
Thank you very much. Update on the project. Staff has coordinated with the owners of the Country Pines Homeowners Association and the owners of Pabcor. We've had a couple of meetings to discuss the Plaza Drive issue and getting it repaired. Country Pines owners are all in favor, and all 6 of the owners have signed on. The owners of Pabcor had requested an opportunity to do comparative pricing. Also, they're doing survey work to find out exactly how much of the road they really own. And as of last week, in communications with Pabcor, they had not gotten all the information from their surveyors yet. And So therefore, this is where it brings today. Obviously, with the cold weather and the snow tonight and the asphalt plant's now closed, the project is not going to be able to be completed this winter.
Okay, we'll, hold on. We'll key you in as soon as Dan Peterson is done, okay? Go ahead, Dan.
Okay, so at this time, I had communications with Marty Rand, the president of the Country Pines Homeowners Association. I updated him where we were at, and I had left a message for Mr. Arvanitis I just said PABCOR, wanting to know when we could expect reports from their civil engineer and their supplement bids, their cost comparisons to see where the project is. That is where we are at today.
How long does it typically take someone to
Alderman
get
Messer,
these
go ahead.
reports? Sorry, Mayor.
That's all right, go. How long does it what?
Does it typically take for someone to get these reports that PAPCOR is saying that they need to get? Is it reasonable that they haven't received them yet, or should they have received them by now, and we're kind of dragging things along here?
That's a very good question. It could take some time for the civil work to be done, a month, 5 weeks to check titles, check plats, have things redrawn and confirmed. In terms of getting price quotes, that should have been fairly quick.
So if we were to give them a deadline that they either need to give us a response, or we're going to proceed with legal action, as we discussed before, what would be a reasonable deadline to give them to get back to us on this?
30 days.
I don't know if anyone else has any other questions or comments, but I'd like to see some sort of a deadline given to them in writing that we need a response by, and if not, to take action on our end.
Mr. Mayor, if I may
Yes,
say
sir.
a couple words. I thought that we had given direction in executive session for them to do this, and then if we did not get the definitive answers, and I don't know what that timeline was, that we would begin the process of finding them. I'd like to ask the mayor, you know, you have the most experience in this world, for them to get a survey for the property, how long should that take? A week?
Well, I've had, no, surveyors are not available in a week, possibly over the holidays, but it's been too long.
Right, but I mean, how long should it take? Should it take a week and
I
normal?
think to get a
day-to-day?
survey anywhere from 1 to 2 months on a commercial piece,
Okay,
not on your house, for example.
okay, but,
So they've had that time.
sure, agreed.
So
I
I think
think
we're
that we
faced
keep-
with a couple of things. One is put them on notice, as you're requesting, I believe. And, you know, the problem putting them on notice is, what do we do if they don't comply? One of the things we may want to consider, and we spoke about this just today with Kevin and Joe, maybe we want to do nothing. Why are we trying to force something that isn't ours? They pay for everything if they have a problem. And all of a sudden, we're taking over and we're having them dedicate streets that they will never again be responsible for. So maybe that's something we should think about and/or suggest to PABCOR. If PABCOR doesn't move, we can't go anywhere. We've got everybody else, but PABCOR is probably, what, 30% of the cost?
Maybe more, I think about 40.
The situation is this, is that is considered private property, and that would have to be maintained as any other property in a commercial, like a parking lot of any of the shopping centers or other private alleyways or parking areas would need to be maintained. So we can start the process and get them on and, you know, put them on notice, and then with the first break in the spring, when the asphalt plants open up, give them they should have a deadline and maybe take it to court, but then it would be a private property, and it'd be up to each of the owners to do each of their share of the road, so you would have 7 owners, each doing a little part of the roadway.
If I could expand, Mayor, your comment of doing nothing, I don't believe, and I think that it's not up to our codes or ordinances, not up to our property maintenance standards. There's been complaint from the fire department saying that they're having issues with traveling through there. I believe that PAPCOR has done nothing but be a roadblock in this process. I want to say, and Alderman Messer, forgive me if I'm wrong, but wasn't the last time we really spoke about this almost 3 months ago?
I believe so. It's been a
So,
while.
I mean, we've gotten nowhere with this. I'm almost of the opinion that, you know, and Alderman Ludwigson and I spoke about this at one point, you know, blocking off that street and just closing it off until they have everything back up to city standards.
Well, my comment was related to, when I say doing nothing, put them on notice, it's their street, they should go do whatever. I believe we would have the right to block that street. That's my personal opinion, because I've gone through it before.
Well, they've already received a notice of violation, so
Right.
they're already on notice that their private drive, for lack of a better term, is out of compliance with the city code. So the city is working at this point. I would characterize the city's efforts as working to resolve that without some sort of prosecution. But that is certainly, they've already been on notice that they're in violation, and prosecution is usually, in housing matters or property code matters, is the next step when there's non-compliance. And you can either get a court order ordering them to make the repair, and assessing fines is usually the next step.
Okay, however, in the case of the association, if this was reversed and it was an individual that was out of compliance, that association wouldn't hesitate to begin the process of finding them to get them into compliance. I don't know why we're handling this any differently, why we're handling it with kid gloves. We've been playing around with this for 5 years.
Before I was on council.
Right, right.
So I think that they've been put on notice several times, as a matter of fact, not just going back 3 months, but they've been put on notice, and now it's time to take action.
Mayor, if I may further
Yes, ma'am.
expand. As far as us taking over the road, that was us trying to help by saying if they got it to code, we would take over so they didn't have to worry about it in the future. So we were trying to work with them on getting the road fixed and then keeping it maintained. They wouldn't have to worry about it. That didn't go well because PABCOR started making unreasonable requests. But I thought before we had said, if we've already put them on notice and they're not maintaining the property per our ordinances and code that they need to, take legal action. I thought we had already authorized it to go to that step. They've obviously had a lot more time to come back and get information, and I think it's time that we say, you have 30 days. If we want to be generous, give them 45, 60. I don't care. I wouldn't go past 60 days. If they want to gather information and possibly work with the city taking it over, so fine. But if we don't have an answer by a certain deadline, and they're not making any efforts, they don't have proof that they're making efforts or taking steps to get the repairs done, that we take the legal action that we need to take. I mean, like Scott said, I mean, if our own fire department is concerned about driving on the road, that just tells you how bad it is. I mean, I drive on that road almost every single day, and it's horrible. It goes to where people live. A lot of people drive on it. It's probably not the safest, but, you know, if we're going to allow them to have the road, then they need to keep it up to code. And if not, then we need to do whatever we need to do in the best interest of the city and all the residents that drive on it, including our fire department.
Well, just to note, the fire department wants to keep that road for quicker ingress and egress. Putting up Jersey blocks tomorrow, which we might be able to do. In other words, block it with the big block cement things. But what have we gained? If the fire department says, hey, we can't get in there fast enough because we're coming from there.
Well, and we don't need to block it, but we can take the legal action and get
No,
a
but
court
that
order
was,
for them to repair it.
Right, that was a recommendation a moment ago. So, Alderman Ludwigson, what's your point of view?
My point of view. You ready?
Go.
Okay. First of all, if they wanted a survey and this was something they were gonna benefit from and it was good for them, they already would have had it. I'm sure of that. Second of all, this came about years ago because they came to us wanting to give us that property for us to take it over. So we told them what the plan was years ago, as far as them contributing to make the repairs and turn it over to us. I'm losing interest in it now. If I'm Passport, I do exactly what they're doing. If I'm dealing with us and our reaction, then I would do exactly what they're doing. They're doing everything right, we're doing everything wrong. I don't know why we're not there every week, or whatever our code says that we can go there and write a ticket for to do it. Otherwise, is this really an issue? Is this really a safety issue? Because I can't believe that it is if we're treating it the way we're treating it. It's obviously not a safety issue.
Mayor, may
So-
Yeah, go ahead.
say something, just to clarify, writing tickets every week, unless there's something new. Once there's a violation and the violation is ongoing, under Illinois law, every day that property is out of code is a new violation. So that's where so unless there's some further deterioration that creates a new violation under the city code, once we put them on notice of the violation, that starts tolling it. So, I mean, I think it would be useful to remind them that from the date of the notice of violation to date, what the potential fines could be under the city code for their failure to fix it. Now, I think that if we've been working with them to try to resolve it, they might have an argument that, these fines don't apply for that period of time, but I think that if you want to get the ball rolling, having some direction to the city prosecutor, to the building department to issue a final notice of violation, give a definite time to remediate the issues, otherwise, file something.
Is there a ticket number? Dan, is there an actual P ticket that's been issued for this?
That can be issued first thing tomorrow morning.
So it hasn't been.
No, because we were directed to continue to work with them. Country Pines secured their final owner. They provided more information, and we had 2 meetings to come to this conclusion, and it's been about 5 weeks since our last meeting. So tomorrow morning, they can get a final
Nothing's
notice.
changed with the deterioration. It's the same as it's been for 3 months ago, 6 months ago.
Actually, since then, someone has gone out there and patched some of the potholes, but it is not in what I would say is a good workmanship-like manner in a good street.
So if we believe if we believe it is a safety issue, the ticket needs to be issued, and we need to follow through with it. If we don't believe
Correct.
it's a safety issue, then leave this thing alone. I'm inclined to not even participate anymore. Let them keep that street.
Thank you.
Let them keep it, be done with it, but hold them accountable for complying with our city codes, with our ordinances, and do what they're supposed to do. I mean, if somebody doesn't cut their grass, we fine them and we go cut the grass. So I don't see this as any different than anything else that we have, where the city takes action if they feel that there's really something wrong. You fine them and you go out and do the work for them.
I would advise against doing the work for them because of the sheer cost of that, but we can get them into the courts. Now's the time to do that and get them in and get a judgment so that it can be upheld and enacted as the minute the plant's open.
So could we put that on a timeline? Could we say,
Yes.
nothing's changed, you still feel a ticket's justified?
Yes, there's been no action to come to the table to get
So
this
we can
in
have one
compliance.
issued tomorrow and get in line at Rolling Meadows.
Can I expand on that?
Well, let me just say that we do have 6 people that are signed up. Is that what we have?
Correct. We have the
So
6
We've
owners.
got them. It seems to me if we put the notice out there, whatever form we want to deal with, I think those 6 people have to go to PABCOR and speed this thing along.
Well, they all have to get it. At some point, that shopping center I can't imagine that there is not some kind of easement or egress agreement between that shopping center and there. I can't imagine that doesn't exist. If it doesn't, shame on them for not having it, but they all have to get one. We can't just go to PABCOR and say, we're going to issue you the ticket. Everybody who's part of
Right,
that street has
right.
to get one.
But I say they'll go to PABCOR as a result, because they've already agreed to make the payments.
But that does us no good. We've been sitting on that for a year.
Give them a deadline, do the court thing, whatever, but put them on notice, give them, how long do you want to go, Alderman Messert, 30 days?
You write
I mean, there's
the
nothing
ticket,
you can do
We're
right
going to
now.
wait 30 days to go to court on the ticket anyway,
We-
so.
You're right. Right.
Less than 30, we could do it in less than 30 days, give them one final proper notice. If they fail to respond, to submit the application, their documents and that, so the very next day, on the 31st day, we can have the tickets written and into Rolling Meadows in the circuit court.
Alderman Dolick, how do you feel about it?
I agree. I don't think there's any reason to delay this any further. Start by writing the ticket to whoever it applies to, get it into the court system and start moving it along. I think that it is a safety issue, and I think that's the foundation of this. It needs to be addressed, and I think we've kind of delayed this for too long. I think start taking legal action and get something done about it. I don't want to delay it anymore.
Alderman Rosenthal?
I agree with my colleague. It's been way too long already, and at least it's my impression that what they're figuring on is they're going to wear us down, and eventually we're going to walk away from it, and they're going to get off scot-free. I'm going for the enforcement, the penalization of them, and doing it of a sufficient amount that it will hurt. So basically, I'm in favor of going forward with the necessary enforcement. And if 30 days is 30 days, the sooner the better. It's been too long already.
Well, factually, nothing can happen between now and when the ground thaws, but that's not a reason to withhold. Let's go ahead with it. I am in favor of it, certainly.
Can we get a motion to
Yes.
this?
Sir, if I could add a couple more things.
Yes, sir.
I think you bring up a very, very strong point, which is they can't do anything right now. Okay, we can get the survey done and hold them liable for that, but shame on us because we let it drag out to this point. But unfortunately, if we go and we cite them today or tomorrow, and then they're subject to additional fines moving forward until April 15th when the ground thaws and the plant's open, we can't do that.
It's not necessarily true, because let's say there was a water main break that froze and thawed and froze and heaved the road, we would be able to bring a road to compliance in January if we have to. Is it cost prohibitive? Yes, but that's not our fault now. So, yeah, okay, we're willing to wait, but we gotta go to court, get somebody involved that can tell this guy he's gotta do it, get the plans done, and be prepared to do the work as soon as the plant's open. But can he do it now? He absolutely can do it. The plant's being closed is not our problem. That's his problem. But we're putting him on notice now that he's got this issue. But we're willing to work with him to, remediate this in the wintertime, so it's good enough to be used, and then have a plan for spring in February, so that they can, when the plant's open, get the work done.
And have a firm start date of April 15th.
The only reason they can't do it now, there's no
I'm not
reason they can't.
advocating for them, please don't misconstrue what I'm saying. I just want to say that their hands are tied right now. I do recognize that.
It's only financial hands. It's not that they can't do this road, believe me. They could do that road right now if they had to, but we're willing to work with them.
Okay, well, see, I wasn't aware of that. I mean, I know you can go get patch and stuff like that, but to actually reconstruct a road, I didn't know you could do that.
To bring it to safe standards until they actually can do the final work. I mean, they can bring that, they could do.
They can
what
get
they
in
need
there
to
and
do
they can
there.
patch, they can
Right.
have, okay. It's just,
We also have to be concerned about insurance. I mean, somebody's gonna get run over, somebody's gonna get a flat tire and go off the side of the road or something. We have no insurance. We should ask for that also.
can we recommend, or do we direct, or do we have no part of saying that they need to hold a co-owner agreement for future maintenance of this parcel?
I mean, if you're not getting involved in remediating whatever the issue is, then I don't think you have any standing to require how they interact amongst each other.
Okay.
It's a private
It's a
matter.
give and take.
Now, if we're getting involved and they ask us to get involved and we draft an agreement that includes us as a party, then we can include whatever we want to include in that. But I think at this point, that might be a little, that's in the future. And I think what you're looking for right now is a motion to direct staff to issue a final notice of violation with a 30-day deadline until a citation is going to be issued, and then we can address any additional issues as they arise after that.
Okay, and
So moved.
if I can ask one final question of the attorney. So we're going to give this 30 days. You already have one half of the ownership on, on board. We're penalizing ownership, correct? We're not penalizing one or the other. We're penalizing the owners of the parcel as a whole.
And that's why I think they'll run to PABCOR.
It would be directed, the citation would be directed to the owner of the property in question.
Right, which includes
Okay.
the,
Which doesn't rule anybody out. It's the owner
Right.
in its entirety.
Mhm.
Okay, thank you. Pat, you want to make your motion?
Yeah, so moved on Kevin's previous motion.
Second.
whatever you say.
Right.
We'll take it.
All right.
All right, so we have a motion, we have a second? Anyone?
I think Laura made a second.
Laura.
Oh, I seconded it.
Oh, you did, thank you. Roll call, please.
Alderman Williamson.
Aye.
Alderman Messer.
Aye.
Alderman Dolick.
Aye.
Alderman Ludwigson.
Aye.
Alderman Rosenthal.
And it is 30 days from today?
The notice will go, excuse me, the notice will go out with tomorrow's date on it. It will be delivered tomorrow.
Okay,
What is today?
thank you.
Brings us to other staff and elected
Let me just
officials.
ask, have we ever used the police department to deliver a notice like this before? We've got to impress the people involved that we're serious. Al, have you guys ever been asked to serve notice on some particular matters like this?
Like the PAPCOR
Yeah,
issue? No.
would you do it?
Would I do it? Yes.
Well, let's do that. Whoever's there, that's who gets to know it.
Yes, sir.
Everybody agree with that?
We
I
have.
think this is a function of the building department, and you have a code enforcement component to it, and that you should follow the proper channel. You shouldn't try to use intimidation technique.
Well, Mayor, may I?
Go ahead.
So it would just be, as opposed to sending out via certified mail or something, it would just be personal delivery by the police department. It's done, liquor commissioners use it a lot of times so that you're certain somebody got notice. I've dealt with situations where even if you send certified mail, they'll say, oh, we never got it, and then there's a service issue. So personal delivery is the most efficient way, whether or not it's done by police or a messenger service.
Any other comments? Yes, sir, go ahead. Well, that's the reason I brought it up.
I'm sorry, you couldn't hear what he said.
The seriousness of it might be better with a police officer showing up at your front door, at your front door, someone's front.
I mean, I'll roll with whatever the majority is, it's fine.
Are we good with asking our police department to serve the notice? Just a voice vote, yes, no? Everyone in favor?
Yes.
Aye, except you're not.
Aye, that's fine.
Okay, all right, let's proceed then.
Mr. Mayor, other staff and elected officials reports?
Where are we there? What happened to the consent agenda?
We're not there yet. We're still at reports.
Oh, okay, where were we? We go down the line, everybody had a chance to talk? Joe, how about you?
No reports, sir.
Okay. I don't have anything. Am I missing someone? If so, speak up. Al, how about you?
I've talked enough for one night.
Well, someone might agree with you on that.
No report.
We ought to put him in a jack-in-a-box. Then he can pop out. Oh, I didn't say that.
Happy holidays.
There you go. That's a good report. Thank you. Anyone else? If not, we'll move on.
No report.
No report.
Just want to wish everybody a happy holiday.
Good. Let's remember that there are people that are losing their homes as we sit here and enjoy ours. So it's not good times for many people out in California, for example. But we should wish everyone a Merry Christmas. Kwanzaa is coming up. I think Hanukkah's already, it is tomorrow. Okay, my calendar said last week. So we have Happy Hanukkah, Happy Kwanzaa, Merry Christmas. Did I miss anybody? All right, we can move on.
Thank you, Mr. Mayor. Brings us to no items for the consent agenda. Old business. We have second reading of the staff memo and ordinance for a zoning variance for 697 Glendale in consideration of the Plan Commission Zoning Board recommendation.
Mr. Mayor, may I make a
Yes, sir.
clarification?
Go ahead.
Thank you. I sent an email to elected officials earlier this week, and I just wanted to make the clarification on the record because this was discussed in the last meeting. In order to, the voting requirements for a variation that comes with a positive recommendation from the PZBA is a simple majority vote. The only time where a supermajority is required is when you're overturning a negative recommendation from the PZBA, which is not the case here. So it's a simple majority vote tonight, one way or the other. Thank you.
Okay, so we are going ahead with the second reading then. Motion to have the second reading for an ordinance for the levy assessment of 2017, staff memo and ordinance for a zoning variance for 697 Glendale. It's the second reading. Can I have a motion to that effect?
Motion to approve for discussion.
Second.
All right, we have a motion, we have a second, open for discussion. Alderman Williamson.
Obviously, I've been the most outspoken about this, and it is within the ward I represent. I've given some significant thought to it, and my original no does not hold true anymore. I've been thinking about it, talking to people, and I'd be willing to compromise it. I do not want to accept it as it sits today. Right now they're asking for a 4-foot variance for the width of the driveway. I'd be open to, you can take the podium, Joe. It's fine.
Mr. Attorney, would you come up, please? Thank you. State your name.
My name is Alfred Stavros, and my law firm is located at 433 North Milwaukee Avenue, Wheeling, Illinois. I've been practicing law, this is my 40th year, and I specialize in some municipal litigation, zoning, and I've handled many cases of this nature. I've been asked to represent Mr. Pascucci tonight for what we consider this to be called a non-structural variance for driveway. I've looked at the plans, I've seen the plans. Your attorney should tell you, and I'm sure he knows this too, that every piece of property is unique and a hardship exists to this piece of property as is presented. The detached garage, which has been approved, cannot be reasonably and safely accessed with the existing code ordinance for a driveway with the setback. The way it appears is that because of the offset, and if you do back up a trailer on the driveway, let's take, for example, a snowmobile trailer, even if you went to a 10-foot driveway versus 12-foot, that's requested.
I don't want to be rude nor interrupt you, but I will. Why don't you listen to his compromise before you try and relitigate going through and getting the full variance? So
I thought you
hear what
said
he
10
has to
feet.
say.
Is that correct?
Oh, I
No, you guys
I
talked
hadn't gotten
about-
there, but I had earlier conversation with
Well, I apologize.
Joe Senior.
I thought that you said you went for 10, you would agree with 10.
All right, let's hold it, Mr. Stavros, and let's let you finish, and we'll call you back. Alfred,
Okay.
that's all right.
The
That's fine.
3-foot variance that you're talking about, I mean, my information is showing that you're looking to go 4 foot into a 5-foot easement. Is that correct?
Well, Matt, the architect and engineer here for the site plan that you all should have had a copy of. Am I misspeaking? Did everybody get a copy of this? Okay. The way the driveway is laid out, and correct me if I got this wrong, I think it's 120 feet by 12 foot. And at the one spot where it jogs to the left, well, depending how you look at it, it'd be jogging to the right.
Mr. Stavros, if I could stop you for 1 second and read this to you. On August 24th, 2017, the PZBA held a public hearing to consider a zoning variance request to allow construction of a driveway 4 foot into the required 5-foot side yard setback.
Well, I thought it was a 3-foot. Am I wrong in that, gentlemen? Or is it a 4?
Mr. Peterson can.
At the August meeting, it was discussed the 4 foot so you could get the curbing in and the detention basin on a 12-foot, and you needed the foot, you were going to keep a foot of green space, curb, driveway, curb, and a little space between the house to accommodate the 15-foot. So that's why the variation came out of committee with a 4-foot variation into the side yard.
So,
That's what was presented at the hearing.
right. Right. So with the condition of the curb, but the curb originally was discussed to be part of the driveway, and then it was discussed to be a green space of a foot. Is that correct?
But the site plan corresponded with the 4-foot request, so that's what came out of Plan Commission. And
Is
that's
that
what
correct?
was written up.
Because I thought it was a 3-foot, but I stand corrected. I mean, if we're talking about the curb not being part of the driveway, I think that's where the miscommunication.
Yeah, because as was explained by the engineer, you had the house, a 6-inch curb, 12 foot of clear width driveway, 6 inches of curb, and then a foot of grass. So therefore, you needed the 4 foot into the required side yard. And that's what was
You're absolutely right if you're considering the curb as part of that driveway. Okay?
Can I ask a further question?
Sure.
Is how far is this away from the house? I mean, you're talking about house, curb, driveway. Isn't this offset from the house 12 to 18 inches?
There's approximately a 12-inch space from the foundation to the back of curb, and there, according to the engineering, there's a sump line that goes in that area, there's a little bit of green space that goes in that area, then there's the curb. So, yeah, you're looking approximately 12 to 18 inches of, again, this is a little small, but what was shown and testified to was approximately a foot between the back of curb and house.
Thank you. So, Mr. Stavros, my proposal is to allow for a 2-foot variance, which would afford for a 12 or a 10-foot wide driveway, and then removal, a caveat being removal of the existing secondary driveway on the east side of the property that goes to the side and that widens and leads to the side of the garage,
Well,
so that there's not a secondary driveway again. So we're removing it, we're putting a standard driveway, and then adding a new one.
Well, I don't know how the second, I mean, this is a compromise you're proposing, right? But it's not part of
Correct.
the requested variance.
Pardon me?
It's not part of the requested variance to
It is
remove.
not part of the requested variance, but if you're looking for me to approve the variance,
Well,
that's going to be my comment.
You know, I can't speak to that's certainly up to Mr. Pascucci. I'm just here to address the issue of the standard for variance and the request as it's presented. If it's going to be curb, which is a 4-foot variance, and then they're looking for an offset of 1 yard set off on the side.
And this is not foreign. I mean, I reached out to Mr. Pascucci Jr., asked him to give me a call. I received a call back from Mr. Pascucci Sr. We spoke about this, and I thought I was giving a courtesy so that we weren't just making decisions on the spot here.
I understand, but I'm not the owner of the property, and
I get it.
You know,
I'm just explaining to you
legal
the timeline.
standard, which, again, legal standards, and your attorney is here, is that this is a non-structural variance request for driveway. And not to lecture anybody about how these cases work, but the way they work is that they're always First Amendment violations, your right to use your property without governmental interference, is it reasonable, unreasonable? And here the standard would be that this offset, this requested variance is necessary and reasonable to access the back of the garage in the way it's laid out and the way it's been approved. Now, if you took, just for example, and I don't know if anyone's ever backed up a trailer, but you have to take the front of the vehicle and point in the opposite direction with the trailer to go. And if you keep an 8.5-foot standard snowmobile with trailer, and I'm just using that because I use snowmobiles, you only have 9 inches on each side based on your compromise, your 10-foot. And even the best CDL drivers would have a very hard time of backing up a trailer, getting around that house to access the garage. So if you increase that to what they're asking for, you'd have approximately 19, 20 inches on each side of the vehicle to make the necessary maneuver of the front and the back of the vehicle in the trailer if you were going to back in and out of that garage. And that would be a reasonable use of a person's garage, is that they would use it in that fashion. And not every
Stavros,
day.
I didn't say it would be easy, but
Well,
it's possible.
So,
Anything's possible.
right, but
You're
wait,
exactly
Scott,
right.
you guys are talking about what's reasonable for backing up a truck. I mean, I know every town is different with what they probably have written in their codes, otherwise there wouldn't be individual codes for all the
exactly
cities. So one of our standards for a variance is that the current or previous occupant can't cause a situation that requires a variance for the use. So explain to me, and I'm being dead serious, explain how building the garage isn't causing the required variance that you're asking for, saying he's entitled to enjoy what he wants to enjoy. How is building that garage not creating the purpose of the variance?
That's why the word variance is there, because,
Oh.
no, let me explain.
Oh, go ahead.
Okay? I'm not trying to lecture anybody about property law, but the first thing you learn in property law, in law school, is every piece of property is unique. Every piece, and they're like snowflakes. There's never two pieces the same. I think your lawyer will tell you that. So when you pass an ordinance uniformly to affect every piece of property within the village, there's going to be situations where it's not going to be reasonable to every piece of property. And in your case, I think you have to show a hardship. In this situation, they created a building pocket for a garage, and it's offset to beat the side yard. It was approved. But to reasonably access that, the standard that they look at, and the courts look at, is the reasonable request, the request for variance, is it reasonable? Does it adversely impact the surrounding land uses, which it's, in my opinion, it does not. It adjoins a vacant piece of property that may or may not be buildable. Does it impose an adverse impact on the general public at large, a health, safety, or welfare concern? And it does not. So by you, if the village would not approve the variance, then constitutionally, there would be an argument made that there may be an infringement on the property owner's right to reasonably enjoy the use of the property. That's how these cases are argued. This is not and should not be a complicated variance. Now, I understand everybody's concern, and I did sit here at the last meeting, and I did not address any of you. And the questions from predominantly were you going to use a tow truck in that garage? And I personally don't know how that affected the request for variance. This is simply a request to put a driveway in to access, a reasonable access to the garage that's been approved.
Mr. Stavros, I'll address that. When you say, why did we bring up the tow truck?
No,
The
I didn't say-
original-
I didn't say
Hold on,
that.
excuse me. We listened to you. The tow truck was the basis of the variance. That was the hardship. And that's the way it was explained to the PZBA, and that's the way it was originally explained to City Council. So, of course, that was part of the consideration at the beginning of this.
That may be one of the hardships. That's certainly not the hardship for the standard for a variance. The variance is the hardship created as it exists and the use of that property. Now, that may be a hardship for a private use of a person's property, but it doesn't apply to a variance hardship. I mean, the hardship, I think, and I wasn't involved in that aspect, was to use it as a first responding vehicle. I don't think that's what's the issue here. The issue here is whether or not the variance requested adversely impacts on the surrounding land usage or creates an endangerment, health, safety, or welfare issue to the community at large. And if it doesn't, then the law basically says it should be granted. And if you don't grant it and he can't, then it creates an adverse impact on his constitutional right to enjoyment use of his property. I'm just saying that's how these cases are argued. I'm not saying that's how this case is argued. I mean, we're not looking to go to court. We're simply asking for something that is reasonable here. It's necessary to safely utilize that garage.
Correct. And I'm coming back to you with something more than a no vote, which I was originally intending on providing.
I'm not the owner. I agree with that.
Okay. I'm coming to your client
Right.
with something other than the no vote that I was originally intending to cast and offering a compromise or a solution to it.
And, I consider that to be, a good, a gesture on your behalf, but I'm not the owner of the property, and I was just asked to address that issue, and he is certainly here and well able to address the issue, and you're asking that he incur expenses to take away a driveway that exists that doesn't cause any problem to any surrounding land uses in order to get this driveway.
Can I ask why he doesn't use that driveway then to get access to his garage?
Well, that garage, I have no idea, but he certainly could park a vehicle on there. I mean, it's an existing driveway.
Mayor.
I mean, you know,
I don't know that we have any situations in the city that I know of, or anybody that's come to us to ask for a driveway where you're going basically 97 feet across from the center line of the house with paved or building. I mean, you're full width of that lot. You're going full width. And if you were coming to build a house there, we would tell you you could go, what would it be, Dan? 70 feet is the width of the house, or would it be 15 feet on each side?
Correct.
And, you know, you have a garage. So, I mean, the hardship is not the garage itself. You already have a garage. You're not getting rid of it. You didn't turn it into a rec room or anything like that. And you're saying, I have to have a garage. The hardship is only created because you're putting that in the backyard. And you're saying, not only that, but you have to access it with a vehicle. I mean, I get it. I mean, I understand what you're doing with it, but we didn't create the hardship. I have a problem, like I said at the last meeting. Now, you gotta remember, we've went 180 degrees on this. You came to us at first, up until the last meeting, saying, I need this thing because I want to park my tow truck there. Then you came back, you were gonna do a text amendment, that didn't happen. Now, your new presentation within the past 6 weeks has been, now I need this variance for my driveway, and it's not because of the tow truck, it's because I want to use the garage. But you creating the garage is what's creating the hardship. I mean, there's no two ways about it. Our code is very specific to say you can't create a hardship to ask for a variance. A hardship is not grantable because you've created a situation that requires it. I don't know, if you're not going to build the garage, what would you do with this driveway? And it's the purpose of this driveway is because of the hardship created with the garage. I'm just saying, maybe you need to let your client come up here and answer these questions, because I'm saying he could do something today if he wants to. And that's really up to him.
Mayor, may I have a turn to speak?
Yes, please.
Okay. I'm going to start with the pad. I'm not quite sure why the side pad on the east side got brought into this when it's not part of the variance request. I understand trying to negotiate with people, but I'm not quite sure why that became part of the negotiations. It was there when he bought the property. It's in compliance with our codes and ordinances. So if he doesn't want to remove that, I really don't see why we should ask him to. As far as the variance request that was submitted to us, yes, initially it was for a tow truck. He learned that the tow truck isn't in compliance with our ordinances, and therefore it cannot be parked there. He understood that. But the variance request is still the same, to have a 4-foot variance into the side yard. This council, by unanimous vote, approved a 4-foot variance and a 5-foot variance just last year. So I don't know how we can sit here and say that our issue is it's encroaching too far over when unanimously we approved the same variance plus a 5-foot variance, which left nothing left. And the 5-foot variance, they also had another garage. So if we're saying he doesn't have a hardship by needing a garage because he has one, we approved the same thing. I understand some of the concerns with wanting to vote no, but I also think there's a little bit of hypocrisy when you approved something just a year ago that was the same exact request, if not even more, and they already had a garage too. So it's like the same exact thing that we're looking at. It's on the west side. Why he's not using the pad to go back is because that's on the east side, and his neighbor asked him not to put on the east side. He's trying to accommodate his neighbors, so he's going to the west side. His
not
neighbor,
really-
can I finish? Everyone else can finish without interruption.
Please
I
don't
would
interrupt.
like
Go
to
ahead.
as well. My understanding is the neighbor that had an issue was at the PZBA meeting with his attorney, and both of them had no issues with it if it was on the west side of the property. My understanding is most likely the property adjacent to the west side of this property is not going to be buildable. I feel like we're nitpicking now about 2 feet, and we're not really approving how wide the driveway is. We're not approving whether or not we think someone can back a certain size vehicle up. We're approving a variance into the side yard setback. We've approved the same thing before. We've set precedents by doing it. This council, including those who are against it now, approved these variances. So why we can't do this one now, I'm having a hard time seeing the valid reasons not to approve it. Thank you.
Thank you. We call up Mr. Pascucci. Why did we call you up?
I wanted to answer Alderman Lovett.
Identify yourself, please. and-
Joseph H. Pascucci, the owner of 697 Glendale Drive, Prospect Heights, Illinois. The answer to your question is originally, we had brought to Dan Peterson a couple options. One of the options was on the east side of the property. After applying for permits and going through the PZBA and talking with Dan, talking with the neighbor, we realized it wasn't probably the best choice because it would have been too close to the neighbor's house. So again, as Alderman Messer said, we then moved it to the other side, the west side, and the neighbor who was the only neighbor who had an issue was fine with it. He had no problems after that, once it was moved to the other side, and it was more of a smarter choice because it had no impact on anybody because of the fact that it is next to, adjacent to a vacant piece of property that is unbuildable and a complete 100% floodplain area.
All right, to comment on that, your neighbor opposed the tow truck. He never said that I didn't want a garage back there. He said I didn't want the constant activity of a truck back and forth in the middle of the night, all hours, it's gonna be loud. That's what he opposed. So that's why it was moved to the other side. You gotta remember too, up until, this isn't even a new application, so I'm not even sure this, I'm not even sure I like the protocol of how this went, because I don't think this was, Dan, you can correct me if I'm wrong, a brand-new application for a variance, or did it just kind of morph out of the original variance?
In
The
consulting.
same case number?
Yes, in consulting with the attorney and trying to, let me back up a second. There was still a side yard variation being requested for a 3-foot to build an attached garage to the other side. So the side yard variation was the original request. It just happened to now switch and trying to accommodate the neighbors, accommodate the space in the building, a side yard variation on the other side, but now instead of building a structure, it was a lesser variation for just a driveway. So that's why it was allowed to be amended and brought back to the PZBA as, because it was technically the same variation, actually a lesser
Correct.
impact.
No, I agree, but this goes to Laura's point that she was making about why are we doing this one different. The original intent of this up until, when was the final application or modified? What was the date of that? To be just the way it is now? The current one, is it 6 weeks, 8 weeks?
It was before the Plan Commission for, the original one was in April or March, and then the revised one, I believe, came back in mid-April, and then there was a number of continuances. I believe it was April 17th was with the revised, and I don't have the exact dates with me, but I can get that to you. But then there was a number of continuances as well. Mr. Pascucci worked through the flood control ordinance to see if he could even build the garage, to see if he needed to go for a variation on the flood control standards, to do the engineering to see if it could be built. There was approximately 3 to 4 months of continuances while he did the engineering, and then came back and proved through the engineering that the garage could be built in the backyard and meet our flood control standards and did not require a variation, which then was able to release the case to public hearing to the PBZA in August.
So the original case, which is still the case that we're looking to approve today, technically by application number or application for the variance, has changed from, this goes to Laura saying, how can we do this now? Why are we picking on this now? We weren't fighting the issue of the driveway originally up until this came about now. Prior to that, it was a tow truck, you can't use it for that. You went back and forth with, you were gonna do the text amendment. I think the text amendment was applied, was it ever applied for?
Yes, the text amendment, after the PZBA recommended approval of this application in the driveway in this configuration, Mr. Pascucci came before this council and asked for a continuance of that action to give him time to apply for the text amendment. The text amendment was applied for, and during that process, Mr. Pascucci withdrew the application for the text amendment and understood that the tow truck, trying to get the vehicle over 12,000 GVW was not going to be successful or move forward, and decided that he was going to continue with the garage to use it for personal belongings, as he testified, and seek the side yard variation for the driveway.
Which brings us to today.
Which brings us to today.
So going to Alderman Messer, I got the implication from what you said that we couldn't, it implied we couldn't get him on the tow truck, now we're gonna try and get him on the driveway. That's not true. I brought up at the last meeting my dislike of going to the side yards. His attorney, Mr. Pascucci's attorney, brought up the fact that every zoning case is different. Every application of a special use for a request to the city is different. Every lot's different, so everything has to be taken individually.
Pat, can I clarify?
You didn't let me, but go ahead.
Well, before you got too far, I wanted to say in your thing, okay, if you thought I implied what you thought I implied, that was not my intention at all. When it was the tow truck, I was a no vote. But it's not. It's just the side yard variance now. He learned that it isn't in compliance, and he's complying with our ordinance and not putting it there. My comment about now is that last year, we unanimously, your concern is the side yard variance. How much is going to, we approved a 4-foot and a 5-foot variance.
So everyone, okay, thank you, Mr. Mayor. Everyone is different. I don't recall last year's being that we were gonna have 97 feet of coverage left to right on a lot. Everyone is different. Maybe the shapes of those lots were different. Something was different about it. It wasn't just a pure, let's go to the full width of the lot, let's do this or the other. The reason why this comes up, you said, well, why are you asking to get rid of that other driveway on the other side? Well, are you going to, at our next meeting, make a motion to eliminate the 5-yard setback for a driveway and just go lot line? I mean, what with this case would say that we shouldn't just do that? I mean, we should. And then we get rid of all these hearings for 5-yard encroachment into side yard for driveways. Let's just be done with that. Because there's nothing here. You already have a garage. The old hardship for a garage used to be, I want to stay here. I made my house bigger. I made my house bigger. I built into my garage. I no longer have a garage because it's not in my family room. I'm going to put a garage in the backyard. Okay, well, you don't have any issue with your garage. It's to code. It's a 720 square feet. But I need some encroachment on that side yard for the driveway to get back there. At least that was a hardship. Somebody's asking us now who already has a driveway on the other side of his garage to put another driveway on the other side of the house. I mean, at what point does it end?
He can't put another driveway there without getting an approval for a variance as well. He doesn't have the room over there, and he doesn't, so he wasn't going on the east side. But you're saying they already have a garage, the other one already had a garage too. It was the same exact thing, and you gave them a bigger variance.
It's not the same exact thing.
But you're saying if he already has a garage, it's not a hardship. This one already had a garage, so that couldn't have been a hardship.
Was that a pie-shaped lot or a rectangular lot on the last one? Do you remember? You don't. No, it was just a question, because she doesn't know to say that it's exactly the same. And I'm not trying to pick on you. I'm just saying, in my opinion, you're throwing it at us like we've approved these before, just keep approving them. At some point, it will never end. We'll have 80% coverage on lots. We'll have driveways on both sides. It'll never end. My point is, I've argued against this before with the house on Drury that went all the way out to the edge, and we had problems with it. The neighbor didn't like it. I don't like this. If he's willing to accept a compromise so we don't have driveway at 97 feet across the front of the lot, I'm willing to accept that. Have you addressed
I'm not
that?
willing to accept shortening my driveway on the east side, because therefore that driveway was there before I even purchased the house. So why should I change an existing
But
driveway?
you're here asking for a variance so that you could put all your
Correct,
stuff
on the west side.
on the west side. For what reason? Tell me why. Why do you need that driveway?
For
The shed?
many reasons. I've got a shed that is dilapidated and it's falling apart in the backyard.
So you need a place to park your vehicles, you need a place to put your stuff. I get it. Why do you want the side driveway? Because that's a place to put something.
I can't put the driveway on the.
No, I'm talking about why do you want to keep the other driveway? Why would you want to keep
Because I
that?
need the driveway to enter the garage on my east side.
I'm not saying get rid of the driveway. You're misunderstanding it then. We're talking about just a bump out to the side of the house.
Can I say something?
Sure.
Yeah.
Yeah.
Why should you have to look to the cost of removing the pad that's already there, just so we can have the garage on the other side? I don't get it. I mean, what are we doing here?
I don't know what we're doing here if every time a variance comes up and we keep going further and further and further and more and more and more and more and more, it never ends.
Okay, but like you said, okay, this guy comes in, he's got a house, he decides to take his garage, make it into a family room. Now he's got to do another garage on the other side. He's doing improvement. That's all my son's trying to get, an improvement. A nice improvement. He's trying to put all his stuff in a nice enclosed garage. That's it. It's simple.
I get it, but we're asking you, so the aesthetics of that neighborhood isn't a driveway at 97 feet wide, or a buildable, or building use 97 feet wide in front of your house. Like Laura says, Alderman Messer says, what's the next standard, 98 feet? Is it gonna be 99, or will we go 100?
Pat, just to step back, do you know what size property that was that you approved a 5-foot variance
No,
on?
I
Okay,
asked-
so neither of us remember all that far back. The main
But you were
issue-
sure it was the same, is what my only point.
To me, it's the same type of variance. The issues that you were bringing up was how far we were going into the setback and that there's already an existing garage. So based on that, it's the same scenario. You gave more of a side yard variance and they already had an existing garage. So based on the arguments that you're giving, you already approved something
Because
for
we don't know
those
the
same
details
reasons.
of those cases, so.
All right.
And I have
Let's
one more
come
comment.
to order, please.
Can I make another comment?
It's gone up and down. Are you going to change something you haven't said?
Yes.
Go ahead.
Yes. So one of the things this council was looking at is commercial trucking and vehicles and large vehicles being parked in driveways and out front, and how we can get them to the side and to the back and covered. People who are against him doing this are proposing that to clean it up and so it looks nice. Right now, he could take his truck, his cars, all stuff, and park it in the front, and it can look all cluttered and not look nice. What we're proposing to do to get the larger vehicles off and hidden and covered, he's able to do that with this. So, I mean, even think about what we're trying to do as a city going forward with getting larger vehicles, boats, whatever, out of sight. With this, he's able to do that. It kind of achieves one of the things that we're talking about going forward with and changing the ordinance to be able to do anyway.
And that's exactly why I would suggest removing the east side driveway, so we don't have that issue of something else on that side.
If you
Not
change
the
the
driveway,
ordinance, you'll
I'm
address
talking
that.
about just the parking spot.
Can I say something?
All right, last comments, please. I mean, we've gone through this 5 different
Can I
ways.
just address one issue? Councilman, I think what you're talking about is called judicial review. And on a case-by-case basis, if what is done here tonight would adversely impact on his rights to enjoy his property, his right to quiet enjoyment, then that's how the courts reverse these decisions. And what you're suggesting has nothing to do with the application of variance that's on file. And I understand your argument, don't get me wrong. But maybe that should have been addressed somewhere along the line when he was going for the garage, it's already been approved. But what's before this board now is a simple variance. And the reason it's called a variance is because uniformly when you pass an ordinance to affect all property within the village, because of the uniqueness of every piece of property, there's going to come a situation where you have to vary from that ordinance. And this is one of those situations, and the courts have improved the standards of which you would comply with. So I'm not here to tell you how to vote. I just think that the reasonableness of the request is not unreasonable in this situation. And I think that if you listen to her argument, it makes perfectly good sense. It's not what happened in the past. It's on a case-by-case basis. And it does clean up, it would clean up. And he would not be parking any vehicles out front. And you do have ordinances that address those parking of abandoned vehicles and things of that nature. This is a simple, non-structural variance for driveway. The most simple variance that's requested before the zoning boards. So again, I think the request is reasonable and it's necessary. And
All
that's
right.
what you vote for.
Thank you, Joe. I only have 2 quick comments. One is Alderman Ludwigson says what's going to happen in the future. None of us know what's going to happen in the future. There may be no one that'll ever come up and want the same variance, or there may be 100 people. That's why you have a council. And the next council may very well approve something a lot worse than this that you consider bad. I don't consider it bad, but I don't vote, as all of you know. And secondly, we have a motion, we have a second, we had a discussion, and we're looking to move ahead with the second reading for the variance for 697 Glendale, Prospect Heights, Illinois.
Sir,
Thank you.
before a vote is taken, I think there's an important question that needs to be asked.
He didn't hear you, I'm sorry. Yes, go ahead.
When
Well, that really is what's happening. The PZBA unanimously approved what we have been talking about for the last hour.
Some of the conversation was difficult to hear from my cell phone here, so I just wanted clarification that our vote will be either to approve or reject the recommendation to the PCBA.
Not technically. Go ahead, Kevin.
Alderman Rosenthal, it's actually you're voting to approve the ordinance as is presented in the packet. It comes with a positive recommendation from the PZBA. So it's a minor clarification, but that's
The ordinance is a product of the PCBA's recommendation.
correct. Well, the ordinance is a product of the application and the recommendation from the PZBA, but the council is not bound by the recommendation.
The question that I have directly impacts his.
All right, Alderman Rosenthal, is that it?
Yes, sir.
All right, thank you, Alderman Williamson.
The question is for the applicant, Mr. Pascucci. I have made a proposal that we could change this to vote upon tonight, okay, being 10-foot wide, removal of the bump out on the east side. So we can change it to that and vote on it as such, or we can vote on it the way that you have applied for and has been recommended by the PZBA. So I leave that to you as your decision. And then we can address Alderman Rosenthal.
I'd prefer to vote on it as it appears, with the way it was presented.
Okay.
All right, thank you. Have we clarified all that? We are looking to vote to pass on the second reading as approved by the PZBA and as we've talked about tonight. So we'll take a roll call. We'll start with Alderman Messer.
Aye.
Alderman Dolick.
No.
Alderman Rosenthal.
Aye.
Alderman Ludwigson.
No.
Alderman Williamson.
No.
Motion fails 3-2. Why do we have a PZBA? I mean, if we're going to knock them off the block, why don't we just make all our decisions ourselves? Moving on.
I asked the same question, why we have codes if we're not going to vote on them as a council for the variances. We should just make it a zero lot line, make it easy, if
Well-
that's what you want.
Good. Thank you for your comment. We're moving on, Joe?
Item 10B, and I'm going to ask if the council would entertain a motion for omnibus, because these are all basically perfunctory ordinances regarding tax levies and the second reading. It's for the levies for the special service areas, just a number of myriad of items that we discussed previously.
All right, so the request is for an omnibus vote for items B through H
So
under
moved.
Section 10.
So
Okay,
moved.
we have a motion.
Second.
We have a second. Roll call, please.
Alderman Williamson.
Aye.
Alderman Messer.
Aye.
Alderman Ludwigson.
Aye.
Alderman Dolick.
Aye.
Alderman Rosenthal.
Aye.
Motion passes 5-0. Go ahead.
Which brings us to item 11A, under new business, a staff memo and request from Players Pub and Grill for disbursement of tax increment financing fund per Players Pub and Grill City of Prospect Heights redevelopment agreement. Mr. Peterson would inform the board or the council that they have completed the remaining work of the parking lot. So their request has been made.
Thank you. As Administrator Wade has said, the city has inspected the driveway pre-pour and final pour and striping for the players. That was the last outstanding item that we had from our department for the conditional occupancy permit, and the project has met the requirements to be issued a full certificate of occupancy, of which, now that that's finished, Players has requested their final payout of $54,000 and some change there.
Questions, please?
I mean,
Yes, sir.
is total completion, there are no punch list items left, correct?
Not city punch list items, no, there are not.
Okay, and then I'd like to make a comment that moving forward, we need to be a lot more clear in black and white with how these contracts are written up, because this was very loose and gray, if you will.
I second that.
So
I
that
would
was my
agree.
only question.
I would agree with those comments. The work is done, so this needs to be paid out, but I think that money could be better spent if it's closely monitored in the future.
Well, not just that, the contract had contradictions within itself. It was very poorly written.
I might add that someone on this council took umbrage with the staff, with the people that work here, and were admonished for having written contracts. I can assure you, and Joe can assure you, have never done that. Any contract you've seen or reviewed was done by the city attorney, not by anyone on staff. So that's kind of a kick in the pants that I sure didn't appreciate, even though nobody kicked me. Must have forgotten me. So,
Mr. Mayor, I had a question about the
Yeah.
memo. The math didn't add up. I don't know if anybody else noticed. It said that there was $427,000 in receipts that have been submitted. The owners were paid $449, leaving $50,000 and change left. Does that mean we don't have everything we need, or do we have everything we need?
We have everything we need. I reviewed all the receipts from the last $50,000 payout, and in double checking what had been paid to them, there was $449,600 and some odd dollars that had previously been totally paid out for this project to date. So there was a balance of the 53,000.
So we gotta get a release from them, because if they come back later and say the agreement said you're gonna pay me receipts, and we're saying we have less receipts than what we paid them, I don't want them asking again for
No,
difference.
yeah, I understand that. In total, they have met, they've spent today about $1.4 million in that project, and the receipts have been double-checked, and I will work with Kevin in getting a release written so that will satisfy that it's paid in full, and that's it.
anyone else, please?
Yes, sir, if I could expand on that.
Yes,
So
sir.
the total receipts due, we're paying out a total of $500,000, correct?
Correct.
So the receipts due or do not add up to $500,000?
It well exceeds 500,000. They spent close to $1.4 million on that project.
Okay, but the receipts submitted specifically for this reimbursement total up $500,000?
The receipts that were submitted since the last $50,000 payout,
Okay,
okay, was approximately $400,000. We only owed them $50,000 is all we owed them.
okay.
So yes, the receipts that they
Okay,
spent,
I just want to make sure that
yes.
in total, we're not paying more than what it was. So it's 1.5, whatever.
Correct.
Okay, thank you for clearing that up.
All right, our learned attorney has a question.
It's just a comment. It's, they submitted qualified expenses, project expenses in excess, of which they're only entitled to $50,000 more, approximately $50,000 more. That's why there's that discrepancy, so.
Thanks for clearing that up.
I have a question, Mike. Are there sales taxes paid to date?
Currently, Players Pub is 1 month delinquent in their eating establishment tax, and they are delinquent in paying $1,000 in fines for 2 previous late payments.
And they were previously late, but they caught up and paid
They
$1,000
had been
fine?
delinquent for 3 months,
Okay.
as well as been delinquent on the $1,000 fine. This past Friday, they paid 2 of the 3 months that were delinquent. There is still 1 month outstanding and the $1,000 fine.
Okay, so I know you keep tabs on everyone's sales tax, if they're up to date or not, so let's keep doing that. All right, if
I'd
there
like
are
to
no,
ask that no payment be made until their accounts are brought current.
I don't think you have to ask that, I hope.
yeah,
Or I could offer an alternative. I could if with authorization, deduct the balance that's due and deduct that from payment.
I wouldn't mix the
No?
two.
Okay.
I wouldn't, the council's decision, not mine, but I wouldn't mix the two.
I don't know what the rules are with TIF funds, if we would want to do that.
All right, if we're okay, then the payout happens, is that right? We need a vote on this?
Yes, we're spending money, so if we could get a motion to approve the final payment.
Motion to approve the final
Mo-
payment to Players Pub, $50,000.
Motion approved to make the final payment to Players Pub upon their clearing up of any outstanding balance due to the city.
Okay.
Second.
All right, roll call, please.
Alderman Rosenthal? Aye. Alderman Messer?
Aye.
Alderman Dolick?
Aye.
Alderman Ludwigson?
Aye.
Alderman Williamson?
Aye.
Motion passes 5-0. Moving on.
The staff memo and resolution approving the agreement between City of Prospect Heights and Metropolitan Alliance of Police, as noted in your packet.
All right, should Al address that, or do we know what we're doing?
No, I think it's explained in the packet. It's a successor agreement. We've come to agreement between the parties. It's what's recommended by the negotiating committee.
I move to approve.
Second.
Second.
Roll call.
Alderman Williamson?
Aye.
Alderman Rosenthal?
Alderman Rosen? Yes, we have a yes. Thank you.
Alderman Dolick?
Aye.
Alderman Ludwigson?
Aye.
Alderman Messer?
Aye.
Motion passes 5-0.
C, request for waiver of first reading, staff memo and ordinance to adopt Illinois Vehicle Code in entirety for enforcement by City of Prospect Heights. As noted, this is a change in the state's attorney's office, and this would enable the city prosecutor to enforce any of the items from the Illinois Vehicle Code.
And we're asking for a waiver of the first reading.
Correct.
I move we waive the first reading.
Second, please.
Second.
Roll call.
Alderman Dolick?
Aye.
Alderman Rosenthal? Alderman Ludwigson?
Aye.
Alderman Williamson?
Aye.
Alderman Messer?
Aye.
Waiver of the first reading approved 5-0. Moving to the next, approval of the same topic. Joe?
Correct. This would be second reading of that matter.
Okay. DO 1733, motion to approve the second reading
So
of
moved.
the one we just passed on the first reading.
So,
All right, we have a motion,
second.
we have a second, we have a roll call.
Alderman Messer?
Aye.
Alderman Williamson?
Aye.
Alderman Rosenthal? Alderman Dolick?
Aye.
Alderman Ludwigson?
Aye.
Motion passes 5-0. The liquor license fees, we're going to hold till next month.
We're not going to waive first reading, so. we can
Okay,
just-
so we can just go ahead with it, okay?
Right.
So go ahead, Joe.
This is first reading of the staff memo and ordinance regarding the adjustment of daily permits, City of Prospect Heights liquor license fees. As discussed at the last meeting, this would enable the city to charge a single event permit license fee of $1,000.
And also, what I would like to add on, coming up next month, is every single liquor license be increased. And I will make the recommendation to Kevin, and maybe we can get all of that at one time when that occurs. Any questions?
No.
The only question I have, Mr. Mayor, is are they gonna pay $1,000 just to be open late? I mean, you're talking about $1,000 just for a
One night.
couple hours. Yeah,
Right.
that's a,
I
That's a
might
big
remind you that this was your recommendation, and I agreed with.
for $1,000 for a late?
Yes, that's exactly what you said,
For a one-time,
for a one-time
For one
event,
day.
for a extra curricular event.
I read this to be that it was like on the days that, they're already open for, like, New Year's Eve, where we already addressed that, and where we talk about that, New Year's Eve, the day before Thanksgiving.
Right.
Is that what you're talking about with would that be a special, is this above and beyond the ones that are already addressed in the code?
First of all, the fee for those events was $100 up till this, until this issue is approved, to be more than that. But we did discuss it, and I thought it was a good idea. So we got it started that way. If you don't think that's a good idea, then forever.
No, I just want to be clear on it. We right now tell our places, and it's up to you, you let them know, that yes, you can stay open later on New Year's Eve if
Right.
it falls on a weekday.
costs you $1,000.
Yes, you can stay open on, but you want to do that. I don't think I think what we're talking about here is different, where it's a special.
Mayor?
Yes, go ahead.
No, it's exactly what you're talking about. It's on the code, it's considered a special late hour license where they apply to the liquor commissioner for extra hours on certain days of the year, like New Year's Eve or like the Wednesday before Thanksgiving. And this is an add-on one-time license for them to stay open later than their normal liquor license would permit.
Okay, now I'm going to be 50, so I could be having a senior moment here, I don't know. But my idea of the extra hour increase was a tag on top of your regular license to say if you wanted to stay open past our standard of midnight, or whatever time we agreed to in the new code, that you could stay open till 2. And that's what you'd pay extra for. I don't know about the special event issue. I seriously don't remember that. It could be that I missed it, but my push was to say, we're reining back our 3 o'clock licenses to be earlier, but if you want to stay open until 2 and you're established, you could pay an extra fee to stay open later throughout the year, not a one-time special event, if you will.
Go ahead.
This is separate from whatever the new liquor code is gonna look like.
Right.
This is in relation to the liquor code as it exists right now, which has a special category that's for one time, I believe it's 3 times a year, and
Right.
it's at the liquor commissioner's discretion to grant these extra licenses. So with regard to what you were discussing earlier, that's not addressed here, and that's addressed in the draft total overhaul of the liquor code.
Right, which, that's why I was confused, because that's what I was talking about in the past meetings, was allowing you to stay open later till 2 AM. If you are established and you pay a different fee for that. So this is new to me, so I just don't want this to be the Ludwigson amendment here, because I didn't come up with this.
Well, you speak so eloquently, I thought you would enjoy being.
I'm not opposed to it, but I thought this was out coming up since we were redoing everything anyway, how this came up before. How did this come up before just sticking it into the new code? What brought this about?
The mayor raised it, I think with the upcoming holidays. There was a few discrepancies that the mayor noticed in our current liquor code that he wanted to address. This was one of the items. The other item was for charitable organizations, but we resolved that without having to amend the liquor code.
And we do have, you know, the $100 applies, Karen, to everyone for a liquor license?
Yes,
Everyone.
everyone
Okay.
per
Well, it's
event,
not my
per
intent
event,
to
so.
raise everyone by $1,000 for a special event. It's strictly the intention of a basically 4 o'clock type operation to increase the fee.
And theoretically, under the new code, this same category would exist, because even if somebody petitioned
Right.
for that late 2 AM license, this would still be an add-on to that 2 AM license.
Right. But the fees would be different. 2 AM license extended special event would not be $1,000.
Have we been assessing that, what I call holiday extension during the week? Have we-
$100.
They've been paying that?
They've been
Yeah.
paying $100 per event.
Okay,
So per evening.
per evening.
Any other questions? So you'll get more on the liquor thing next year. Joe, where are we?
Brings us to item F, is a request for approval of city council meeting calendar for 2018. And I just want to call out, it's been noted that on the dates published, is September 10th is also the Rosh Hashanah holiday.
Now you tell me.
September 10th. Asking that that be changed.
Which one is that?
September 10th.
I know, where is it?
It's on the,
Regular schedule?
yeah, the 2018 regular schedule.
All right, well, in the past, we've moved it to Tuesday in some cases. Is that what we're looking for?
Well, Tuesday is the second day of Rosh Hashanah.
I would just like to note, it will be difficult for me to make any meeting any day that's not a Monday. If you change it, that's fine, and I will just give advance notice if I can't make it. If there is a meeting on a Monday that I can't make, I don't expect you to change it for me. I'll just give you notice.
Well, thank you.
So you can do what you want with the calendar.
Well, that's for September. Why don't we not worry about it right now, and we'll try to work
Why
something
don't you
out?
make it the following week on the 17th? The 17th, the 18th is Yom Kippur, but the 17th's okay.
We'll, let's work this through, okay? We don't need to do it here.
Okay.
We'll get it done.
Because you already have Labor Day in September,
Joe,
too.
when does this need to be complete by?
It's an issue.
Joe?
This is in
Well,
Schedule, you can
You
move the
you
schedule.
can always adjust the schedule, I mean, as long as it's not the January, February meetings or so, we could revisit this.
You could approve it as presented and then
Yeah.
amend it.
Just
once
flag
a-
that as for attention for.
We've
other
already been FOIA'd about it, because it has to,
Oh,
it's
the
supposed to be by the, yeah. but they
Okay, well,
tell us- I don't know if
you know,
this is a fact, but by
the obvious one, May 28th, nobody's coming here, the offices are closed, nobody's going to be here on Memorial Day.
Oh, good one. Good catch, Alderman Williamson, okay.
When do we
Maybe
have,
I-
to-
Labor
when do
Day
we have
one,
to
too.
publish this?
All right,
But
First of the
Already.
year, or?
Oh, no,
It
second.
really actually should been, like I said, we've been FOIA'd already have it published.
Well, it sounds
Let's
like
just
it could be
approve it and
amended.
modify it.
Yeah.
I mean,
approve as presented and then modify it.
down the road.
No, then it won't get modified, because that's what happens every year. We always have this problem.
Wait a minute, wait a minute. You're questioning something that we might forget, you're saying?
Yeah, because
It isn't gonna
this
happen.
happens, this
Thank
can
you
happen
for
in
your
a couple of years
comments.
in a row.
Thank you for your comment, it will be done.
in the past, we've always had the Memorial Day meeting, the day after Memorial Day.
Yeah.
It falls on that. Columbus Day, is that an office day? I mean, are people here?
Most people are
We
still
are here.
working.
Yes,
What's that?
Most people are still working, businesses are open.
So can we
Post office
maintain
is
that one?
closed. I think so.
Okay. Veterans Day, I mean, we've always maintained a meeting on Veterans Day and honored the veterans this past year. Is there any issue with that?
I don't see any.
No.
No, schools are open on Veterans Day if it's a weekday.
Okay, and then, you know, I asked Larry and Wendy, is there any issue with the last day of Hanukkah?
Last day of Hanukkah is not a problem for me. Larry, is it a problem for you?
Say that again, I didn't hear you.
The last day of Hanukkah.
That's not a problem.
Okay, so our only conflict is the September 10th date?
May I ask, Larry, is the second day of Rosh Hashanah an issue for you?
Yes.
Okay, so I thought.
Okay. So, if it's being FOIA'd, we need to get it moving. Can we publish it as is and then reschedule a date for September 10th? Make it the 13th or the week before?
Well, we can actually do that in the morning, we don't have to, we know what the problem is, we just move it, that's all.
I'm pretty sure, I mean, I can adjust my schedule 9 months from now, so.
Okay,
Whatever it
so
is.
The
Oh, we all-
13th's a Wednesday, that's fine.
I won't be here for that.
All right, Joe, in the morning, go ahead.
As a
No, we're
point of
doing the-
information, when you check the holiday dates, keep in mind that Jewish holidays begin the evening before they're
Sundown.
usually published in the calendar.
That's
In the
sundown.
calendar, unless you're looking at a Hebrew or Jewish calendar.
I actually have a Christian one, and it shows when Rosh Hashanah begins at sundown and Yom Kippur. Some of us include everyone. Larry, I never forget about you.
Joe, can you change the 28th to the 29th?
I've got
All right,
Christ the
so in the
King, you
morning,
name it, I've got
we
all the
move the
days.
holiday
The May
one.
28th?
Did you see that, the calendar I gave you?
Yeah, I did, that's
Let's
pretty
just
good.
go on Tuesday, except Alderman Messer can't do it, so,
If I can switch it, I'll try.
all right, good.
It's kind of far out.
So
I just have other obligations every
The 20
other week.
29th, good way to come back from a 3-day weekend, slackers.
All right, so we're gonna work on this, make some phone calls back to Wendy and to Larry if you need to, but let's do that in the morning and get it out. Okay,
So do we need to vote to approve this?
Yes.
Motion to approve as amended.
So moved.
Second.
all in favor?
Aye.
Aye.
Which brings us to item 12, workshop meeting topics, and we have listed discussion of commercial truck parking regulations and review of city liquor code.
Well, liquor codes, you can, I'll just tell you that we're rewriting quite a few odds and ends that are left. For example, the BYO thing, the serving tea and vodka at the beauty shops.
And the revised fine schedule.
Yeah. So we're working on that. I'm sure you all read the articles I sent out to you, and that's the most popular issue now. Beauty shops serve wine.
It's true.
They can't serve vodka, I'm sorry, I didn't mean that. So we're working on that and try to, match up with other cities around us.
And discussion of commercial truck parking regulations, I believe it was at our last discussion of this week, there's talk about how we might inform the public
Yes.
of this in the upcoming Plan Commission hearing that's in January. And at the suggestion and direction of Mayor Helmer, we've added an insert into the coming newsletter, which will be coming out this month, as I recall.
Is that going to be presented as a town hall, or is that going to be presented as a ZBA meeting?
That, right now, is scheduled for the next public hearing, because we've already had we opened the public hearing last month, continued it for proper notification, and then on I believe it's January 25th, as the next ZBA meeting in which it's published to be heard publicly.
Okay, I would ask that we do something informal where residents do have an opportunity to speak. I've been talking with a couple of people myself, and they do have some input, and I'd like to get with you, Dan, and Joe, and we can, and Mike. We can kind of further those conversations, but it is important to have some feedback from those affected by it, and I think it's better to have that in a more informal setting than something structured like a ZBA meeting.
If that's the direction of council, I could amend my article to the dates, if that's the wish.
I believe it's, that's too late to amend the article for the dates, that's going to the press. But we do have it scheduled, as you mentioned, a continuation of the Plan Commission hearing, so.
But at that planning commission, that's where they're going to issue formal recommendation?
What would happen is I envision this to happen, and I've gone through the truck issues in another town, is that there will be plenty of opportunity for the public to give their input, their suggestions, their positions on the amendments. And then, depending on the time of the evening and depending on the length of comments, the Plan Commission could choose to deliberate and continue it for action for a month. So,
All right. Well, I would ask that before that, immediately after the new year, that I be able to get with the three of you as well as one or two people that I've been talking with, and that we can have an informal discussion so we can, listen to the other side as well. Okay, because I thought we were going to do something like that prior to, and it didn't happen that way yet.
I guess I misunderstood the direction from the council, and I thought it was directed to continue it for notification to a next Plan Commission meeting.
Oh, we can maintain it, don't get me wrong, I'm not trying
okay.
to back up.
Okay.
I just want to move forward with others too, because, my opinion isn't always the best opinion. So if we could plan something that works for the three of you.
All right, I'm sure we'll work that out. It's not tough. More is better than one or two, but whatever we can. Wherever we can get
And I
interest.
invite anybody else
Yeah,
that
we
wants to be a
also-
party to it.
We also can have, I mean, if it's beyond two council members, it's got to become a public
No,
meeting.
that I
then.
know. I'm talking about the people that are
Oh.
willing to contribute or not contribute, that want to be heard. So if we get more, hopefully more than two. All right, we'll work on that. What else?
Any other discussion of that matter?
No, it's,
Item 13, the warrants.
Okay, expenses, this period of $116,984.32, regular expenses. The 12/8/2017 payroll posting of $137,989. November Illinois Municipal Retirement Fund, $17,921.20. U.S. Bank debt service payments, $1,391,773.75. Bank of America debt service payment, $188,030. And total warrants, the amount of $1,852,698.27.
all right, motion to approve as presented.
So moved.
Second,
Second?
any questions? Roll call, please.
Alderman Williamson.
Aye.
Alderman Rosenthal. Alderman Messer. Alderman Dolick.
Aye.
Alderman Ludwigson.
Aye.
Motion passes 5-0.
We don't have any resident comments, I
We
believe.
do not.
We do not, okay. And there is, Attorney Carney has a request for executive session.
Thank you, Joe. I'd ask for a motion to move to executive session to discuss pending litigation.
Second. Anybody?
Second.
All in favor?
Aye.
Aye.